This week in No Fear or Favor, we highlight a bill that seeks to raise the age a kid can be handled in juvenile courts from 10 to 13. The purpose of this bill is to better align with international norms and the way we treat our kids. We also ask if jailing preteens is an effective intervention for youth or for public safety. Lastly, we ask what organization would possibly oppose a proposal that would help public safety by in part preventing the imprisonment of preteens. Hello, I'm Jamel Lundy, the Intergovernmental Relations Manager for the Hennepin County Attorney's Office, fancy word for lobbyists. I served in Minnesota House of Representatives for almost 10 years. Hennepin County is the largest county in the state of Minnesota, and the Hennepin County Attorney's Office handles almost half of the state's criminal prosecutions. Follow me as I follow the action at the Capitol with No Fear or Favor. Last week in the Minnesota Senate Judiciary Committee, Senate File 3694 was heard. This bill seeks to raise the juvenile court jurisdiction from the age of 10 to the age of 13. This raises the question, internationally, how normal is it to do what Minnesota does? Place preteens in the juvenile justice system.
The United States Convention on the Rights of the Child gives direct guidance about the minimum age of criminal responsibility couched in a human rights framework. The United States is the only United Nations member state that has not ratified it. In 2019, the UN committee focused on this topic, encouraged nations to increase their minimum age of criminal responsibility to at least 14 years old. With our current minimum age of 10, Minnesota falls within the nationwide average. However, we have always sought to be above average in our care and treatment of children.
Wow, what we're doing is certainly different than most countries, many of which have better public safety outcomes than us. But the question remains, is what we're doing more efficient or more effective?
We know that interventions with youth are most effective when they're immediate. What happens in practice when a 10, 11, or 12-year-old comes into the juvenile justice system, a Rule 20 motion is filed, which is to determine whether or not they're competent. They have an evaluation, and inevitably they're found not competent. Most often, they're not competent because they're just not developmentally mature enough. It's a passage of time. It's not a mental illness situation. And so we just have to keep waiting and waiting and waiting before appropriate supports and services can be put in place.
Well, if what we're doing is both inefficient and ineffective, would preventing youth from entering the juvenile justice system in the first place produce better outcomes? And if so, has anyone tried it?
So what we know is that there are more effective, more immediate ways to intervene with young people. It's about connecting youth and families to the services and supports that they need.
Adolescent development research shows us, and best practices in the fields of like social work and education show that when we can do this wraparound support, when we can involve families, then we can more effectively have the outcomes we want, which is for our kids to be safe and our communities to be safe as well.
This is possible. I joined the Hennepin County Attorney's Office in 2023, and we have been piloting in our office an effort to do this, to not charge children 10, 11, and 12 years old.
It sounds like this is a public policy change that would actually improve public safety by preventing preteens from going to prison. Who in the world would be opposed to something like that?
So the County Attorneys Association, our association, is opposed to changing the age.
Get a sense of why anyone would oppose a proposal that seeks to protect our preteens from the juvenile justice system. We caught up with Malika Iban. She is the executive director of the Legal Rights Center, who's been fighting for this bill for a number of years.
This bill is one that our organization has been working on for a really long time, that nationally there's been a lot of progress on. And what we're seeing in Minnesota is the main opposition coming from the Minnesota County Attorneys Association. And I would say that the critiques that we've heard have seemed to be in good faith and really rooted in questions about implementation and really wrestling with what do we do with young people, especially children this age, when they make big mistakes. What the reality has played out in states across the country who have done this work to raise the lower age, in pilot programs across the state, and the work that the Hennepin County Attorney's Office has done focused on youth diversion efforts, is really that one, our child welfare system will not be overwhelmed in the way that folks will like imagine in their wildest dreams. In other states like Massachusetts and California where they've done this, the data has played out that the numbers of young people referred to child protection are actually much lower than they anticipated because county attorneys are using a more holistic approach to this age range of children, which is exactly what the bill is intending.
If you'd like to learn more about House File 3671 or Senate File 3694, or by Representative Pinto and Senator Pappas, please check out the link below. If you'd like to learn more about the Legal Rights Center's efforts to prevent juvenile justice impact on our youth, please look for the information in the link below. Otherwise, it's been another episode of No Fear or Favor.